All right. Hello, everyone, and welcome back to another edition of Fire Law Roundup. This one for March 1st, 2022. Brad, I'm dealing with my logistics stuff. Why don't you take it?
Sure.
Okay.
We have 5 or so great discussions today. And I got to tell you, Curt, how much I love being an armchair quarterback lawyer. This is just my favorite thing because
it's like being up in the press box at a football game.
It is. I don't have to play. I just have to, offer my
commentator. Right.
Although, look, and to our viewers, I'm a trial lawyer. I'm a litigator. I won a good decision today. I'll share with you later. But
cool.
Okay, so let's talk about some of the cases. And again, this is a lot. Today is a lot of armchair quarterbacking and advice. Not criticizing, but you'll see where I'm going. So the first from your blog is 2 fire officers sue the Hartford Fire Department alleging sexual harassment. Now, let me go through the allegations because these are pretty damning allegations. We're not saying it's true, but the allegations talk about these are my words, but a deep-rooted, long-lasting, widely spread department, which is filled with anti-female involvement, right? And they claim, it's a hostile work environment, and that the environment has gotten so toxic that not only are they experiencing sexual harassment, but when they report it, they were retaliated against. And what they're going after, and I haven't looked at the complaint, but what they're going after is that this, not only when they complained were they retaliated against, but this is just so pervasive that officers that they want to resign. The female officers who get to lieutenant, one resigns because of the alleged hostility and retaliation. So one surrendered her position, and they talk about that there's, they're constantly being degraded and insulted, but they say, in the history of the department, no female has ever risen higher than the rank of captain. And then they state only 2 females have been promoted to the rank of captain. Now, I haven't looked
at one by lawsuit. One of them was by lawsuit.
Oh, was it? Oh, interesting.
She sued to get it. So, yeah.
So here's my comment. Look, we don't know the facts. We don't know the truth. Right. So, but I want to comment that it never should have gotten here. So, I didn't see the date of these things happening, but here's my advice on this type of thing, because this, there's a ton of fire departments strictly male dominated where these allegations can be, can easily be thrown out. And I want to not divert, but say this. I was just lecturing on sexual harassment at a client of mine. I do their annual sexual harassment lecture. I won't name them. And I said, look around the room. I said, there's not one female and there's only one person of color in this room. I said, there's an issue. I said, you may not think it's your issue, but it's your issue. And people got so upset. And that's the problem.
You're rocking the boat, Pinsky. You're rocking the boat.
Yeah, no, they're like, we don't have a problem. But here's what they said. And it's not just them. They always say that. It's not our problem. It's their problem. They don't want to join. Like, wait a minute. When you have 99% white males, I'm sorry, that is your problem. You've created a culture that people don't want to join, don't want to stay, can't stay. I don't know what specifically the issue is, but it is widespread in the fire service. And I just want to get on a tiny soapbox for a second. The reason the volunteer fire service is dying is because we recruit about 25% of our population, white males. Right. I'm not saying only. I have clients that are, more minority and more women. And, but this attitude that, this is our problem or their problem, not ours. No, it's not. This is your problem. And I'm not talking about affirmative action or anything like that. But let's be real. When huge segments of our population don't want to join your organization, that's your problem. So I say that because the fire service, despite people don't want to say it, and I'm not afraid to, the people don't want to say it, we are inundated with misogynistic, anti-everything. It is the way of the fire service. We think harassment's funny. We think sex is funny. We think sexual degradation is funny. Certain jokes are funny, and they're not. It is not how any employer would ever act. So that being said, now we get to here.
Mhm.
My guess, I'm just throwing this out there. My guess is they kept saying there's no problem, there's no problem, or because they did investigate. Now, Mike, so my question is, who investigated? Right? Was it one of the people who are actually a problem, or did they go out and get a private investigator? So this is why I said this should never get here. The moment, and this is so at the end, but the moment that anyone makes a complaint and sexual harassment that relates to a claim of hostile work environment, you don't have your environment investigate those allegations. Right? I mean, the chief saying, oh, I'm going to investigate, or I'm going to get the assistant chief to investigate. That's not a fair investigation. And Curt, you obviously speak on this all the time. But my bet is, had they investigated properly with a neutral party and done real interviews, they would have found a problem if one existed. They would have found a problem and they would have done something to cure it, because the municipality over the fire department certainly isn't going to allow this. So
well, I want to provide a balanced perspective on these cases, and I think that you know, I knew the former chief from Hartford, and I knew that he would not tolerate any sort of harassment or appearance of harassment. But you know, there's allegations, and sometimes you have someone who is a difficult employee. And maybe they're not as highly motivated as they think they are, or the appearances that they're not as highly motivated as they think they are. Maybe they're not as competent as they think they are. And you're struggling to deal with them, but they happen to be in a protected class. And so different things that happen to them, for example, and some of the allegations in this case were that they had to go back for retraining.
12 times, like the blue card training, she had to do 12 times, right? And you can look at that two ways.
Exactly. But here's my point. And I've been lecturing on toxic employee problems with it. And this is not to defend. I'm not defending toxic employees when I say this, okay? But what I'm suggesting is that sometimes we're not totally objective about how we deal with some people who are difficult. And they may be difficult for a lot of different reasons, a lot of which are not our problem, but it is our problem. And particularly when the person is in a protected class to begin with, and it's causing us to look at some of the neutral things that they're doing in a way that is not the same way we would look at the same behavior if it was a white male or other non-protected person. You know, I remember, I don't want to get into names here, but I went when I was with Providence, I went to a rollover accident. We had bodies all over the place, and I mean, I'm never a paramedic, but I've been involved with the National Ski Patrol, or I had been for 40 years, and you know, I've dealt with as many broken legs as probably most firefighters deal with in the course of their career, because that's, you know, so we've got one of the people who was ejected had a severely angulated lower leg fracture, and it was not compound, but it was pretty clear. And I'm a chief now. I'm actually a shift commander, so you know, it was the type of rollover that you have a chief there that's supposed to be directing traffic, or not direct traffic, but just, you know, overall scene safety, certainly not providing patient care. But I can see this person with a severely angry, and one of my rescue officers, a captain, wants to walk the person. And I'm like, did you happen to notice that he's got a severely angulated lower leg fracture, captain? You know, and this guy's a white male, and afterwards, I talked to a couple of people about this officer. It wasn't on my shift. He was, you know, working an overtime shift. And I'm like, what's up with this guy? Why would he? And they're like, oh, that's just so-and-so.
Yeah, we just accept that.
Hello? Oh, that's just so-and-so. That's just,
right.
You know, not, meanwhile, I had a couple of female rescue officers on my shift. If they looked the wrong way at someone, I would get reports about them doing something wrong.
Right.
You know, and this is sort of an implicit bias. It's insidious. We all have it. Okay. But it causes us to see problems. And not that they're not problems, but they're more obvious to us when we don't like somebody, or we have that implicit bias. So, And that can also mean that you have an incompetent employee that needs to be dealt with. But when you stack all these other things on top of that, it's very easy for a plaintiff's attorney to build a sexual harassment case, in my experience. And again, I don't want to spend the entire time we have on that one case, but I think there's two sides to a lot of these cases. But to your point, we've got to address this, the bias aspect. We've got to be honest. I have biases, and I don't know anybody who doesn't have biases. The question is, do you admit that they exist, and do you take steps to try to manage our bias?
Right. And I think that the same thing we would say in any sexual harassment allegation, just to wrap this up, or hostile work environment allegation, is independently investigate, and regardless of the outcome, train, right? Guys, there's been an allegation. It doesn't matter if it's true. We're just retraining you and whatever, right? Independent investigation and retraining. And I'm not saying this didn't happen here. Hartford should not be upset with us. We don't know what happened. It's just, in my belief, if it's gotten to this point, we either did one of two things: didn't investigate and train properly, or didn't act in a way that got somebody upset. And
exactly what I just talked about can cause a department not to investigate, or do a superficial investigation, because particularly where the employee is perceived as a problem employee, you don't do the same kind of investigation as if it was a valued employee that was making the complaint. And I think that's the key thing, that whoever makes the complaint, we do the same investigation, and it's diligent, and we see if there's something there, not to get somebody in trouble, but to figure out, okay, we've got a lot of people engaged in this kind of behavior. Now, as an organization, what do we need to do to correct it?
And I do wonder, and I'll end it here. Right? We got a lot of other stuff, but I'm not attacking the chief, and chiefs in bigger departments, you're just not going to walk up into them. But as chief of a smaller department, I would always say, if anyone's got a problem, come to me. And if you're not happy with what I say, you go right over my head. And I wonder whether there is that sort of comfort with the leadership to say, listen, your captains have a problem. And I would understand people not being comfortable, but you have to tell them to come to you 106 times, right? In writing, and let them know. So, okay.
Right. Yeah. And again, I want to be totally fair. I am friends with the past chief. I'm not, I don't know who's even the fire chief now in Hartford, but I do know several of their high ranking chief officers, and I have the utmost respect for them. And, but I think what can happen seriously is that when you have a problem employee, and I'm not saying these two women are problem employees, but I do know that when someone perceives someone to be a problem employee and they come to you with a complaint, it's handled differently. And we've really got to, it's hard to be intellectually honest about this, but we've got to find a way to get there. And let's move on. How about this Dallas case?
Yeah, let's talk about Dallas. So I want to first preface this for you, because you don't know all of my practice, and for people, I do a ton of landlord, not rental landlords. I do a ton of like fire district acting as a landlord, or I represent a bunch of bars and other property owners who get sued for assaults all the time on their premises. So I deal with this a lot, and I know I know New York law very well, obviously, but New York law and other law is very common across states. Property law is a first-year course we take right at law school.
Second year for me.
Okay, so it's very common. So I don't think this is one of those things where I have a New York bias. But so here are the facts, and then I'm just going to rip into this, but only on the facts, and I'm only going to rip into it as a legal matter. I'm not attacking anyone. So 3 Dallas firefighters were injured from an explosion from a natural gas, and it was metered natural gas, and they're seeking $100 million. And they sue 4 parties, but property owners are my focus for the moment. And what happened apparently was there was a random gunshot that causes a leak in the system, and it goes on for a few hours, and then the fire department responds and the thing explodes, they get injured. Now, in a lot of states, you can't sue, called firefighters law, or there's a lot of names for it. But basically, an injured firefighter is expected to be faced with high dangerous situations. So if they get injured on someone's property, they can't sue. I presume in Texas they can. In New York they can. What's called the firefighters rule in New York has been removed by statute. Most of the times the firefighters rule is created by a court, so it takes a state legislature to get rid of it. So I don't know the law in Texas, but I have to presume that a lawyer who files on behalf of 4 firefighters knows that they're not prevented.
Well, there's always exceptions to it as well, right?
Yeah.
Even in states that recognize the firefighters rule, there's exceptions. So
like setting traps, things like that.
And reckless or gross negligence,
intentional,
or right.
So let's assume they have the right to sue. That the firefighters have the right to sue. So what they say, there's some interesting things, not as interesting as the SCBA will be later today, but they allege that the owners didn't have a proper meter, it wasn't properly inspected, but their main allegation is you didn't protect the gas container device. I don't know what it was. You didn't protect it from a random gunshot. Now, I got to tell you, that is absolutely nuts. Every landowner has a duty, probably all states or most states, has a general duty to protect people reasonably expected to be on the property, right, and lawfully permitted to be on the property from reasonably anticipated dangers. And it's a minimal duty. They don't have to provide perfect protection, right? If you're aware, example, you own an apartment complex and you're aware that people are getting mugged in your area and you have lights up, which are minimal, that's generally enough, right? You don't have to have armed security. So here, against that backdrop, they're alleging that the landlord knew there were random shootings in the area and should have foreseen that this could have been struck by a bullet. You must be kidding. I'm normally not that forceful, but that's a tough road to hoe. Unless there's been like 5 shootings in the past 3 years that have struck this thing. The meter is a different issue, right? So if the meter was improperly functioning and it was going off and should have known, then maybe. But
I don't know. Is there a meter that can detect that though?
I suppose it's moving a lot quicker, maybe.
That was one of the things, and one of the things, like people, one of the classic mistakes that people I think make, not non-attorneys, is that they believe that if there's sort of negligence in the air, that negligence in the air can create liability, right? It really, and trial attorneys laugh at this. I know, but like, for example, somebody gets in an accident and they don't have a driver's license, okay? Right. And you say, oh, well, they're going to be liable. Oh, no, not necessarily, because it's irrelevant. Okay, whether somebody has a driver's license or not is irrelevant. You have to somehow show that the lack of a driver's license caused the accident before it can even be admissible, because the judge will not allow the jury to even consider the lack of a license until you can show that the lack of license contributed in some way to the accident. So why is that relevant here? These folks are going to have to show that somehow this meter that was and let's assume that the meter was negligently installed. It was the wrong meter. It wasn't the right meter, whatever. Okay. You have to show that if they had done the right meter, installed the right meter, that would have prevented this from happening. How are you going to do that?
Right.
Yes, they might have been negligent in installing that particular meter. Yes, it might not have been installed. Bottom line is, negligence in the air doesn't translate to liability, that you have to somehow connect it. And trial attorneys, that's defense attorneys, our friend Chip, right? Yeah. That's how they make their living, is like they just grind, and they'll just try to get the judge to rule that this is inadmissible, this is inadmissible, this is inadmissible. So,
and I just, this is tough. I mean, and look, the firefighters probably, I haven't seen an answer yet, right? The response, but were they keying a radio in a highly gas-filled area? Did they ignite the spot? I mean,
they went on a CO run, so they would have had no reason. They didn't go there for a gas leak. They went there for a CO, and they were apparently meeting, and I'm not sure. I don't know if I don't believe that methane is cross-reactive with CO.
I don't know, but I mean, like normal, like, well, it says natural gas. Was it methane or what? I don't know
methane, natural gas. I guess you're not a hazmat tech there, Brad.
No, I'm not a tech, but I do know.
No, it's methane. Methane is natural gas. Mostly, there's some other, other contaminants in there, but mostly methane. But apparently the CO detectors, I guess, in some of the units were going off. My understanding is, so they were there. Bottom line is, they were not there for a gas leak. They were there for a CO run, at least according to the complaint. I could be all wet as far as that goes, but that's what.
In any event, this is a tough lawsuit, right? It's one thing if you fall, you're a firefighter and you fall on someone's driveway on the ice when the storm occurred 4 days later, or you get hit by a car when you blocked off the road. I had that lawsuit, won it. But boy, this is saying that you should have protected against a gunshot to the natural gas.
Yeah, and I'm just looking at my post on it now. This is one of the ones I did not have a complaint on. That court does not have an online access port for me to be able to access their complaints. So certainly, if anybody listening has access to that, if you're a Texas attorney and you have access to the complaint, love to post it on there.
It's interesting. Okay, so next one's a really easy one. Not a good one, but an easy one, where a fire department boat. And Curt, I don't know if you knew, were they responding to an emergency or just driving?
I spent about a half hour trying to figure that out. I found one post on Reddit that said that they were responding, and there was a drowning, and there was a drowning on July 3rd. I think this happened on there was a drowning on July 3rd, and I saw some reports that the man's body surfaced on July 5th. And it's possible that they were responding to that incident, but this Reddit post, I believe, was from one of the family members of the people who were injured, asking for witnesses, and they said that the boat was responding at a high rate of speed. So that's not in the complaint.
Right. Yeah. For the listeners, the boat ran someone over, but I assume it was daytime. I love they're going to Gilligan's Island. Hopefully, it wasn't a 3-day tour. But they ran over people on a boat, and they're saying they should have seen them, should have diverted, unsafe. We don't have any other facts. I do question whether, in some states, there is some protection against drivers of motor vehicles. So I went back and looked at New York. That doesn't involve a boat. So,
oh, really? Yeah.
Yeah. So it's interesting. I wonder whether there's some sort of qualified immunity statute that protects, operators of a boat. I don't know. So.
And some states have immunity protection for fire departments. I don't know about California, just what theirs are, but it says that while you're engaged in firefighting, and Massachusetts is one of those laws that it limits your immunity protection to when you're engaged in firefighting. And a question in this is a water rescue firefighting? You could argue it. You could argue it's not. Yeah, it may be something fire departments do, but it's not firefighting. So,
and the only lesson I can come over with this is don't run people over with the boat. I don't know.
Yeah.
So we don't have much. So that's an easy one. The next one is super common. Unless you want to go back to that. Are you good with the Honolulu one? We can
Honolulu. Yeah, that's
okay.
It.
So I think since this is your show, you should send me on a quest to Honolulu to make sure I'll go visit some of our FDIC friends.
I've got some good friends out there. I'm sure they might put you to work while you're out there. So
okay. So here. And this is what I lecture at the Fire Academy and lecture all about. This is a negligence 101 case. Not that there is negligence. This is the perfect case to teach about the 4 components of negligence. We're going to focus on one big one, which is proximate cause, because that's what's popping out at me. But so here are the facts. So almost 2 years ago, March 2nd of 2020. And it's interesting. I'm not sure who the plaintiff is. I think the plaintiff is the daughter, which in New York would present a lot of issues. But the daughter sues because, and I want to tell you what she sues for. I just won a case on this, as you know, very tough road to hoe. So the daughter sues because her mother, I think, is in arrest, but certainly not breathing. They intubate her mother, and to get her out of the house, the medics put her in a sheet. Now, it may not have truly been a bed sheet. It may have been one of those lifting things. I don't know, right? We don't know. But they put her in a sheet, which I'm guessing is lawyer, trying to depict this as a bed sheet, not intended to carry, but I'm betting it's not. And I bet it's one of those bags that have 4 handles and you carry somebody out. But nonetheless, and as I talk about this, imagine the scenario to the listeners, viewers, imagine the scenario in your head. You know what's happening. She's intubated. So some person is probably bagging. Maybe another person's trying to do compressions. We don't know how heavy this person was, how tall, how short. We don't know anything, but she's in arrest, it seems. Respiratory or cardiac, who knows? But somebody loses grip, which is what they say. One of the rescuers loses their grip on the sheet, drops the person hitting their head. Drops the victim hitting their head. Now, start with it. The woman is the plaintiff, person suing appears to be, correct me if you think I'm wrong, the daughter. And the daughter is saying what she witnessed caused her extreme emotional distress. Now, I just won a case, as you know, in Buffalo, which very clearly set forth the requirements to win a case of extreme emotional distress. They have to prove that what you did, the person who did the wrong, was outrageous, that your conduct was so outrageous, so extreme, so above the norm, that it caused the person who is standing right there and witnessing it, and we don't know that she was in the zone of interest, standing right there and witnessing it, but nonetheless, it has to be so extreme that it would cause a reasonable person to be overwhelmed with anxiety and permanent emotional stress.
Let's just, I want to clarify one thing, because I dealt with some questions on this on Facebook and folks were confused. So I think it's worth spending just at the time.
Sure.
The daughter did not sue for wrongful death. Okay, really important principle here that in a situation like this, you would expect a daughter or family member to sue because you dropped my mother and you led to my mother's death. Okay. Right. That's not what she's alleging here. Right. Okay. This really important. And I think sometimes we kind of stay at the surface of this, but this is what Brad's take on this, and the take that the attorney had on this is some places call it the tort of outrage, but it's also, I was always taught, the intentional infliction of severe emotional distress. And if you didn't
or
include
negligent.
Right, well, right, they have negligent, but if you don't include severe emotional distress, my professor would take a point off your law school exam, because he wanted to make sure, and nobody ever uses severe anymore, but you'll see it, intentional infliction of emotional distress or negligent infliction of emotional distress. So go ahead, I'm sorry to interrupt, but just so that we understand, this is not a wrongful death claim.
Right, which would be impossible to prove, very difficult to prove, because right, as you said, they would have to show that the dropping her caused her to die, but she's already in arrest. So that would be a tough road to hoe. So, and I didn't see anything that says the blood's gashing out of her head and her head cracked and made a horrible sound. I didn't see that, but let's talk about extreme emotional distress. And again, this is why I said this is basic lawsuit 101. So accidentally dropping someone is not going to be, I would get rid of this right at the beginning. I wouldn't even file an answer. I'd file a motion to dismiss. This would never see a day in court, but for that motion. But I would be saying that the person carrying who dropped their grip did not intentionally do so, clearly. It was not so likely it was going to happen, that it was grossly negligent or reckless or willful, whatever. But it was merely an accident at best. And again, you're bagging a person, you're trying to get person out, you're moving, right? You're making good faith efforts. To prove that's outrageous as a matter of law, I think is going to be very difficult. They're not going to show this is outrageous conduct. Now, had they stood her up on the had they taken someone with a broken leg and walked them out, that might have been outrageous, right?
You want to see the ugly cheap Verone come out? Just try that.
Yeah, right. So, but if you want to throw someone down the stairs, that's outrageous. You want to put them on the board and push them like a sled, that's outrageous. But this is not outrageous. One person losing their grip on a sheet as a matter of law, as the quote, no way. This is not outrageous. So I don't know that it deserves much more than that.
No, other than, I from law school and some of the cases, I think that what the history of this as a tort would usually be someone who's been in the zone of danger when something happens, such as
Standing right there.
you have a couple of people that are street racing and the car goes up on a sidewalk and kills someone. The person who maybe just narrowly escaped it, they weren't harmed but they were narrowly escaped. They're within that zone of danger. Someone who's standing next to someone who's shot, they're within that zone of danger. They didn't physically get hurt, but they suffered emotional distress from that. That's really what the tort is about. And it's been expanded over the years in certain areas, but that's really what the tort was intended to cover. And this is, I agree, it's a little bit of a stretch.
Not a great suit, but
yeah.
you know.
That is what it is.
Right. Now, where we take, I think, the last case, the rest of our time, and I deferred you a lot on this. I submit that you probably have much more of a background on this or not. But the way this is written, according to reports and stuff, okay, so let me say what's happened, because I'm almost at a loss of words for this, because I have so many questions and how things happen to so many people at once. So here we're in California, and 2 firefighters died. They were attempting a rescue at a building fire, and it sounds like they go into the building, and minutes later, although it does, well, I'll explain. It sounds like they lost air, their pass alarms didn't activate, and they say the SCBA was faulty. But this is 2 different firefighters. Right. And from the sounds of it, they made it to a separate floor, located a victim, got all the way in, start calling a mayday. It doesn't sound like, and I don't know how big these are. I don't know if they take 2 breaths and they can empty the SCBA, but they're claiming the reason they were low on air is first claim. And the second part, that their pass alarms weren't sounding properly when they were low on air is what it sounds, but we all know pass alarms don't sound low on air, right? They sound on no air for the most part, or not moving firefighters. So in any event, they sue saying the SCBA were defective. I mean, there's the lawsuit. But one of the things in here really caught my attention, because they said they weren't designed to resist the type of heat they were facing, and they weren't, they didn't, and the SCBA manufacturer, which here is Scott, although Scott and MSA and Draeger and Inspiron, they're all very similar in their functioning, but they said that they weren't properly designed and they didn't properly train them, the firefighters, on heat and all that. And at first blush, look, I do no work for any of the SCBA dealers, but I've worn one for 32 years. I've never had one. I've had my mask fail, right, in a fire, but I know when it's gonna, for the most part. I mean, they're pretty clear about what temperature it fails. I just have a hard time with this suit, and I'm not trying to be hard, but I was curious your take, because, and my hard time is for a couple reasons. One, how do 2 people's cylinders fail at the same time? That really is the chance of that happening, to me, is very low. I'm questioning, did they not inspect them? Were they not filled properly?
Or did they just run out of air?
You just ran out of air. I mean, that's what I think happened.
I don't know. And, I don't want to, again, you've got 2 brother
Let's
firefighters.
Let's get on the line, right?
Okay, you got two brother firefighters that are no longer with us as a result. And we certainly, don't mean to trivialize what they and their families went through. But at the same time, I got to tell you, reading the complaint, I was like, wow, I need to read this SART report, the SART investigation report. And I went through it last night, and I mean, maybe I missed it. It was a pretty lengthy report, but I didn't see anywhere in there where it talked about them having some sort of a premature loss of air, that they were in there, they're working hard. I don't know if they were on 20-minute or 45-minute bottles. So, I guess if they were on 20-minute bottles, 30-minute bottles that only last, if you're lucky, 20 minutes. But the bottom line is, are they saying that the smaller containers of air are not adequate for firefighting, which I think a lot of us feel like you might as well. I think we need the 45-minute ones. But bottom line is, it's not an unlimited supply of air.
Right.
And there was also another thing that kind of concerns me, was that one of the things in the SART report was the importance of medical exams for firefighters and physical conditioning,
Right.
which, you know, we all know if you're not in good shape, you're going to go through your air a lot faster than if you're in good shape. And
Oh, yeah.
I I should be in better shape. And, you know, fortunately, when I was younger, I tried to keep myself in better shape. But I know when you're not in good shape, you're going to go through air. And I
Or if
don't
you're
know.
large, right? You got big lungs, you're large, you haven't learned how to breathe, all these things. You're working hard,
So,
whatever.
but I, at any rate, reading the complaint, I thought that the SART report was going to be a slam dunk about the SCBA manufacturers and maybe the SCBA malfunctioning or some sort of a design defect.
It's not what it is.
You know, so I don't know. Maybe they're hoping through discovery they're going to find something. And one, you know, I do a thing called the legal liability tabletop exercise. I don't know if we've ever done it at your conference,
No,
but it's a good, you know. So what we do is it's really a hypo. So you have a hypothetical lawsuit, and some of them are apparatus related, some of them are structure fire related, some of them are like this, where you have a couple of firefighters who go down. But at any rate, you have a fictional lawsuit and then a fictional set of requests for production from a theoretical lawsuit that might happen after an incident like this. And one of the things is to get set up for this tabletop exercise, you randomly select a couple of firefighters and you randomly select a couple of your SCBA complete with, you know, frame, regulator, and like you say, like engine 8's driver's pack or engine 14, you know, the firefighter rides behind the officer. So you have specific packs that you're going to use. And then you go through the scenario, and the scenario alleges that the pack had a history of problems, maintenance problems, and was not properly maintained. So now what the tabletop is the chief and the command staff come together and say, okay, we have an allegation that engine 14's pack, this particular pack with engine 14, has had a series of problems that we were aware of. And also it hasn't been properly repaired. So now we got to go back to our records and say, can we document, when did we buy it? Who has touched this? Who has repaired it? What repairs did they make? And do we have a history of this? Because then the purpose of the tabletop, it's almost like an audit where you're going to see is our data capture system, is our record keeping system capable of defending us in a case like this where we did nothing wrong?
And let me just jump in. By the way, if anybody has equipment failure, like an SCBA, like an axe that broke, I don't care what it is, you take it out of service and you wrap it. And I mean that. I don't care. You go out and buy big shrink wrap, you wrap it and you don't touch it. You don't move it. You don't inspect it. You save it. Same with a mask failure, right? All that stuff. That is potentially criminal evidence. That is definitely case evidence. And if you put yourself in the situation, right, where you've tampered with something after, it is not going to look good for you. So, and I mean it, shrink wrap it and it'll be inspected by OSHA or somebody.
Yeah. So, you know,
this is tough.
I think, I think if they're going to fail here, it may be on the record keeping part of this. And you've also got some private companies that I'm assuming that they have some sort of private outfit that does their SCBA repairs. They're named in the suit as well as Scott. So, you know, I think fortunately this case does not allege, it doesn't name the fire department as a defendant, but it's not uncommon for us to see fire departments named in these types of suits. And for the fire department to be able to defend itself, we've got to have records about, you know, when did we buy it? How long has it been in service? Has it been repaired? When was the last time it was updated? A lot of these packs, every year or so, Scott's coming out with modifications and stuff. And I'm gonna tell you, Scott comes out with a modification and you don't do the modification to their specifications, and then somebody passes. Now, you know, you're in a bad situation. Maybe at the end of the day, if it goes to a trial, you're not going to be held liable, but it certainly changes the negotiations on a settlement.
And by the way, so people ask me all the time, how long do you keep certain records, like maintenance records, inspection records, whatever? What if they got destroyed, lost, burnt, flooded, whatever? And the answer is you keep your records of inspection for the life of that item, plus whatever in New York would be 3 years, but whatever the lawsuit potential could be. For that. And then you throw in pediatrics, right? If you injured somebody who was less than 18, it could be longer, but get with your state lawyer on this. But you keep those records for the life plot of that object, plus any time they could sue from that date. And if there's an ongoing case or an investigation, you obviously preserve those records immediately. But I think a big case here, a big good lesson here to people is, obviously one, you better darn well have good inspection and maintenance records. You better keep them. But if there's any time there's ever equipment failure, please preserve that equipment. Don't go and do your own investigation. Don't tamper with it. Wrap it right on scene or preserve it right on scene. Chain of evidence is going to be significant in these. And I've had it where I've gotten instructions against the entity. It wasn't a fire department lawsuit, but against the entity who fixed and repaired the item. And I said, you've destroyed the evidence and you should have known. And the judge issues a warning or a penalty against them for, I can't prove my case because they ruined
spoliation.
So yeah, and normally you'll get a letter a couple days after that says preserve it, but just it's a good suit. Anyway, that's I think all of them, right?
Well, we got beyond the blog is a couple of interesting ones. We got we got a fire company that was suspended for lack of credentialed officers. I'm not sure what state that was in. I had a tough time. Let me see if I can get it up here quick. Oh, it's Pennsylvania. So the borough suspended one of 4 fire companies because they didn't have credentialed officers. So again, these are just links in my the email that'll be coming out tomorrow that are really beyond the blog stuff I just didn't have time for. Discrimination lawsuit in a volunteer organization. Former West Virginia fire chief charged with embezzlement. Looks like Buffalo's settled that they had a lawsuit, 3.2 million. It was an injured Buffalo firefighter. There's a new lawsuit by Alexandria, Virginia, an overtime suit that maybe we'll talk more about. Might blog about it later this week. But Alexandria, Virginia, the battalion chiefs are alleging that they're entitled to overtime, that they're not overtime exempt. Really kind of crazy case out of Arkansas, Brad. I don't know if you saw it, but you had a fire chief and then another firefighter in the department that they were running a pool company, building swimming pools. And I'll read from this is WKATV in Little Rock. But they're saying that basically they took somewhere around $415,000 and never put these swimming pools in. And, I think that a lot of times we don't think about our reputation, but many times people look at a firefighter, particularly a fire chief, and there's a certain amount of credibility that goes along with that. And certainly when someone uses that credibility then to get deposits on doing work and then not, finishing up, following through on the work. And I think that's the crux of the attorney, that basically the attorney general now is suing to get reimbursement for that $415,000.
And that's a good topic, actually, as you come to the conference in April or March, where how to ruin your career in a few easy steps. There's a good way. It doesn't matter that it's your fire service that leads to the end of your career. It could be something just because you have a reputable title, right? And it's still going to ruin they relied on you because you're supposed to be reputable, and that same thing is going to bring you down.
Yeah, I remember there was a friend of mine, and I'm trying to think of, forget what department. He had just become the chief of a department, and he'd just moved in, and within a couple of days of him moving in, a person that lives across the street came over and they introduced themselves and, just typical kind of new neighbor kind of thing. And person handed him a key to his house. And he said, well, I just want you to have this just in case, like if we're away and there's a problem, I mean, think about that. Think about somebody moving in from out of state, moving into your community, and you having enough confidence to hand the key to your house and your password to your alarm system and all that goes along with it. But that's the credibility, and that's the credibility that we have. And certainly when people abuse that or misuse it, boy.
But that's the same reason, something I always say, one of my common phrases is the reason we let people steal, and we let people steal from our fire departments, is because we trusted them. So we don't put in any audit policies. But the person who steals from you is always the person you trust. You want to say, hey, oh, you're a crook who stole from 5 other places? Come be my treasurer. Here's our bank accounts, right? And it's always, oh my God, I can't believe they did that. That's the problem. We always trust the people. So I say, look, if you trust the crook, don't blame the crook. That's your own idiot.
Right.
So anyway.
All right. Well, we're just on training missions down here. We're not going to invade Ukraine. We're just on training missions.
Right, exactly.
So there's credibility. There's credibility. Yeah. It's all hype that we're going to invade. So
great. Now Russia's going to hack this blog and shut us down.
That's all right. Go ahead. Yeah, give it your best shot. If they're wasting their time on Fire Law Blog, they're not wasting their time on real important stuff.
Fair. We'll take one for Ukraine.
All right.
Well, this is great.
Yeah, no, last thing, please subscribe. If you listened this far, thank you very much. But please subscribe. We need more subscribers for us to be able to keep going with this. We need more subscribers. So tell your friends, and hopefully we'll see you again next week. Okay.